Welcome to the Australian community. Today, we're speaking with Zjantelle Markel, who is the principal of Markel, a New York law practice focusing on immigration. Zjantelle, welcome.
Hi, James. It's good to be back.
It's been a while, yes. I suppose we should get right down to business. And of course, the hot topic right now is the recent changes to Australian rules with regard to expats leaving the country. Zjantelle, perhaps you could just fill us in on what's happening there.
Yeah, so the Australian government announced on August 1 that Australian citizens that are considered ordinarily resident abroad, that they would now need to apply for a travel exemption as of August 11th going forward if they come back to Australia and then want to leave Australia again. So before this announcement, Australians that were considered ordinarily resident abroad, and what ordinarily resident abroad means is that in the last 24 months, that Australian national has spent more time outside of Australia than inside of Australia. Hence, if you have not been back, if you've gone back to Australia and you're there for more than 12 months, then you're not going to qualify anymore as an Australian ordinarily resident abroad, because then in the last 24 months, you will have spent more time in Australia rather than outside of Australia. So if you are ordinarily resident abroad and you need to go back to Australia, before this announcement, the way you would then leave Australia, as long as it was less than 12 months being spent in Australia. So if you were going back to renew a visa or visit family, or, for any reason that you needed to go back, you did not need to apply for a travel exemption to leave. You would go to the airport with the evidence that you are ordinarily resident abroad. And then at the airport, it would be determined that, yes, you're ordinarily resident abroad, so we're going to let you board this flight and go back to where you are ordinarily resident. So when Australians had to do this, they still needed to take to the airport evidence such as their lease for their apartment abroad, their evidence that they have a job abroad, evidence that they have utility bills, credit cards, in bank accounts in the let's just say the US, because that's our predominant audience right now, but they have other ties to the US. Maybe they they came back to renew a visa and their spouse or children were still in the US. So any evidence that they could show at the airport that they were ordinarily resident abroad was assessed, and then they'd be let on the plane. So what this new rule is that you need to apply for an exemption to leave. In looking at it, James, I think really it's submitting the documents that you would have had to have taken to the airport anyway, but now submitting those online. So the types of documents that they're asking are those same documents. And my guess is that as long as you're able to upload those documents, I highly doubt that those travel exemptions will get denied. I do think that they will get approved. In the regular travel exemptions before this announcement, so there's a blanket travel, inability for Australians to leave Australia right now. So if you are an Australian and not ordinarily resident abroad, you would need to apply for an exemption. So we have been doing a lot of those over the pandemic and helping clients get those. And when we do them, the exemption has been getting approved within 24 to 48 hours. And so my guess is that these exemptions for Australians who are ordinarily resident abroad, I believe that they should come through in around the same amount of time. So it went into effect yesterday, August 11th, and there is going to be a transition period. So if you are until September 7th. So if you are currently an Australian ordinarily resident abroad and you're in Australia right now, if you have not applied for the exemption, even though it went into effect on August 11th, and you are leaving Australia before September 7th, You can go to the airport and go without the exemption. After September 7th, you will be required to show that you have an exemption approved.
So really what you're saying, Zjantelle, is that up until now, any Australian wanting to leave the country that wasn't an expat had to go through this exemption process. And now what just really has happened is that every Australian wanting to leave the country now has to go through this process, whether you're what was previously an exempt expat. It's now it's the same law for everyone.
That's correct. There are some exempt categories still. So, for example, if you're part of airline crew, or if you are a New Zealand citizen, they have an exemption for New Zealand citizens that are in a special visa category. If you are engaged in the day-to-day conduct of inbound and outbound freight, there is an exemption. If you're traveling on official government business, then you don't need to do it. If you're traveling directly to New Zealand and you've been in Australia or New Zealand for 14 days or more, immediately before your travel date. So there are a few exemptions, but those exceptions, are not ones that most people are going to qualify for. So the predominant population that want to leave Australia and travel are going to need to apply for the travel exemption.
Yeah, there was a post on LinkedIn that's received about 6,000 plus views and numerous comments. And the comments go from liking the position that really what's happening is it's just bringing this into line for every Australian. It's the same law for everyone. It also has some other views that, we're living in a police state and we're not even allowed to leave the country, which, may or may not be true, but certainly how people are emotionally reacting to the news. But the reality is, from what you're saying, is that you haven't really seen any denial of exemptions for anyone who is legitimately an expat or has legitimate reasons to leave the country, correct?
Correct. Every exemption that we've applied for a client leaving Australia has been approved. A lot of Australians listen to the media, and the media, there is a lot of hype in the media that we cannot leave, that, we're Australian and we are stuck and we cannot leave our country. I think what Australians need to understand is that you can leave the country. You just need to apply for this travel exemption. And there's a good chance that it will get approved. So you can leave. But a lot of Australians are not even trying, because there's this general knowledge in Australia, because of what people are reading in the paper and the media, that, well, I can't leave Australia. So I speak to a lot of people and they say, well, I can't go there because I can't leave Australia. And I feel like I keep saying, well, but you can leave Australia. You just got to apply to leave Australia. The Australian government is trying to control COVID in the country, right? So they don't want people that are going to be leaving Australia, for a week and coming back. So there is definitely a stronger chance of your exemption getting approved if you can show that you're going to be leaving Australia for at least 3 months or more. One thing with respect to these residents, or Australians considered ordinarily resident abroad, having to file for the exemption having to file for the exemption, is that they will have an approval of their exemption to be able to go to the airport with, and have that security in knowing they're going to be able to leave. Before, they had to take all the evidence with them that they were ordinarily resident abroad and just hope that the airline staff will agree and approve them to then get on the flight. If you're in the US and you're traveling to Australia, you can apply for it before you even leave the US and before you've arrived to Australia. So you can go to Australia knowing that you'll be able to leave.
So Zjantelle, how long before your travel can you apply for this exemption?
So the recommendation is that you apply at least 2 weeks before your anticipated travel, but not more than 2 months before. So you would want to do it within that 8-week window of your travel. I think people shouldn't get freaked out like, oh, I'm traveling in less than a week, it's not enough time. That's just guidance, that says, please, at least 2 weeks before you travel. But we've actually applied for it actually 3 days before someone had to travel and it got approved in time. But, you don't want to be leaving yourself in that position of anxiety, right? So if you do it at least 2 weeks before, you're not going to be up to the wire and stressed out about it.
Zjantelle, I got a question from a member the other day. He's an Australian and Indian citizen, and he just got he applied for the I-129 renewal for his E3 visa, and he got his 797 approval. So he's been approved, his E3 has been approved, but now he has to leave the country to get the E3, the physical E3 stamp in his passport. Now, he also wants to travel to India, but he can't get an appointment in India because there's no appointments available. So in that situation, he has to fly somewhere that he can get the stamp in his passport, and then travel to India to get for his family matter. But then he now has a challenge of traveling back to the United States because there is a travel ban on people flying directly from India, or a general travel ban. So in that scenario, I know it's fairly complicated, but I'm sure it applies to a lot of different nationalities and even just ordinary Australians who do get their 797 approval and need to get a stamp in their passport. How do you go about something like that? Do you have to do quarantine in a third-party country before re-entering the States, or are there exemptions?
Okay, so this is a fully loaded question, James. I love it when you throw these big ones at me. Okay,
these are the questions I get asked.
No, I know. So let me just deal with the easy bit first, which was the last bit that you said. Will they have to quarantine in the third country? That all depends on the country's requirements. So, for example, in London, like if you fly to the UK right now, you will need to do 10 days quarantine there before you could go to a visa appointment or be there. The quarantine requirement will depend on the country that they're flying to, but you are right. So like we'd covered in many of our early day webinars during this period, we had said, the good thing about filing an I-129 in the US is that you can get your E3 status extended, but you don't get the E3 visa stamp put in your passport. So if you want to be able to travel internationally after that, you do need to find a US consulate outside the US that can put the stamp in your passport so that you can then re-enter the US and then re-enter the US for the next 2 years for any international travel thereafter. So yes, we have got clients that their country that they would normally go get the stamp in is a country that has restriction of travel back to the US. So those include India. So your instance right here is India. And then you've got all of the Schengen countries. You've got the UK, Ireland, Brazil, India, and South Africa and China, right? So all of these people cannot travel to those countries. Well, they can travel to them, but it's difficult for them to travel straight back from these countries. So I'm going to deal with your fact scenario, and then we can deal with another hypothetical that we're getting a lot of questions on at the moment. So your Indian national, if there are so these are the options for him. He could either, one, try to get an emergency appointment approved in India. And if he gets an emergency appointment approved in India, he can fly to India. And then at the same time as his visa appointment, he would try to apply for what's called an NIE, which is a national interest exception, to be able to travel directly back to the United States. And he would need to show that to be able to get that approved, he would need to show that his role in the United States contributes to a significant financial benefit to the United States, or is in one of the critical infrastructure sectors of the United States. So that's one option. If the consulate is not going to approve an emergency appointment, then they're not going to approve an NIE either, right? So if they exhaust trying that option first, then they've got another option of trying to find another country that they can travel to get the visa put in their passport. So the difficult part with Indian nationals, which doesn't happen with most Australians with an Australian passport. So if this Indian national is trying to get an H-1B, for example, and is not also an Australian citizen, they would have less options because a lot of Indian nationals need visas to be able to go to other countries, to be able to access a US consulate in another country. the nice thing about it being dual Indian and Australian national is that now you can, as an Indian but with an Australian passport, get into countries like Costa Rica and Nicaragua and Colombia and the countries close by, Bahamas, let's say, because you're traveling with your Australian passport, you don't need a visa to go to these places as an Australian national. So they could then get the visa put in their passport in one of these countries, and then they come straight back. If they then, your Indian national did that just to get the visa put in their passport, and then they did need to have a trip to India, when they get to India, they would need to still apply for a national interest exemption to be able to come back directly to the United States. So they've got two options. One is they do try to apply for this national interest exception, and that can be applied for at the consulate. They don't have to go to the consulate. So it is done online, doing the request with the consulate, but there are substantial waits to get a response on these. So if they don't get a response in time for the time that they need to be able to travel back to the US, there is a subsequent ability to be able to apply for a national interest exception through Customs and Border Patrol, which is the airports. So there is a second way of trying to get it. Both of these methods can, generally you would have an attorney assist you in this process because it's complicated and so forth. So it can become costly and very time consuming. So if you're on a time crunch and you need to be back, with less than 2 weeks, then the other option is to travel from India to a country that does not have a ban of travel directly to the United States if you've been there in the last 14 days, and spend 14 days there. So they could then travel to Mexico, Bahamas, one of these other countries, spend 14 days there, and then they can get back into the US. So if you do need to travel to a country that has a travel restriction back to the US, the ban is that if you've been in one of these countries in the last 14 days, you cannot enter the US directly from there. So you have to spend 14 days somewhere else before entering the US, or get a national interest exception approved through either the consulate in the country that you've visited, and a lot of them require you to already be there to be able to apply for it at the consulate. They don't let you apply if you're physically in the United States because they want to try and discourage people from departing the United States, or through the airport, or spend 14 days in a country, unrestricted country. So I'll move into the predominant questions I've been getting from a lot of clients recently, which is, I want to be able to travel to Europe. Can I travel to Europe? So the first things I ask are they exempt from this travel restriction? And this applies to your Indian national too. The first thing I would ask him is, are you married to a US citizen or permanent resident of the United States? Do you have a US citizen child, or do you have a permanent resident child that's under the age of 21? If the answer to any of those is yes, then they're not subject to this travel ban. So that if the client is one of those, he can get if he can't get a visa appointment in India, he could get a visa appointment somewhere else, but then he could travel to India and back because he's not going to be subject to the travel ban. Similarly, with my clients that want to travel to Europe, if they have, for E3s, for example, if they have a US citizen spouse or a permanent resident spouse or a US citizen child or a permanent resident child that's under the age of 21, that E3 person now has the option of going to a US consulate in Europe because they'll be able to travel straight back because they're exempt from the travel ban. If they don't have any of those, so that's my first question. Are you married to a US citizen, permanent resident? Do you have a child that's a US citizen or permanent resident that's under 21? If they say no to all of that, then I'm like, okay, well, if you want to go to Europe, or any of these countries, it's going to be tough to come back. This is what you're going to have to go through. You're going to have to apply for an NIE at the consulate. And then potentially, if you can't be there for up to 60, 90 days, because that's how long some of these consulates are taking to approve an NIE, then we'd have to subsequently also apply at the airport. The airports only let you apply if you've already applied at a consulate. So you've got to do double. And then we've got to pray and hope that the airport agrees to grant you this NIE so that you can travel straight back. Or you'll have to go to Mexico or Bahamas or somewhere else for 14 days on your way back. The thing that is so critical for people that are going to do this, what they need to know, because a lot of clients are like, that's too much rigmarole. I'm just going to go to Mexico, or I'm going to go to St. Bart's, or I'm going to go to Bahamas for 14 days on my way back. The thing that they've got to know is they cannot or Croatia and Turkey are two places that they can go to too if they're in Europe. So don't do this mistake. If you're going to go to Europe and then you say, okay, I'm going to then go spend 14 days in Croatia or 14 days in Turkey to then come back, because there's no travel restriction to the United States from those places. You have to make sure that the flight from Croatia or Turkey or Serbia, where any of these other non-Schengen countries, does not connect through a Schengen country back to the US, because those 14 days in one of these countries, Croatia, Turkey, wherever it is going to be wasted, because even just going through the airport and a connecting flight is considered being in a Schengen country in the last 14 days, and you will get denied your boarding of that connecting flight. And we've had clients calling us from the airport that just didn't know about the travel exemption. They're like, I just went to Europe for summer and now I'm in Amsterdam and they're not letting me get on this flight. And I was in Croatia for 2 weeks. So a lot of the flights connect through another Schengen country. So you've just got to make sure that if you're going to spend the 14 days somewhere else, that you do not have a connecting flight that connects somewhere that is part of the travel restrictions. So that's something I really wanted to emphasize tonight, because that's so important and it catches so many people off guard.
Well, onto some good news.
Awesome.
I understand that processing times now are actually speeding up. Approvals are going through a bit quicker. Can we talk a little bit about that?
Yeah. So we have seen regular processing of E3s in as quickly as a month. And the premium processing coming through very, very quickly. We're actually seeing fewer R.F.E.s on E3s as well. In professions that are sort of borderline, I still say, don't file as a CEO, because there's the ones that will always get an R.F.E. And then there's ones such as the marketing positions that for a long period, even if you were in marketing or if you were a financial analyst, were getting R.F.E.s because they were saying, well, in marketing, you could have a degree in communications, advertising, or PR, and that would work. And so that's too many varied degrees, so it's not specialty occupation. Or for financial analysts, they'd say, well, you could have a degree in finance or mathematics or economics, so that's too varied, so it's not a specialty occupation. So we're seeing fewer RFEs for those kinds of roles, which is a nice thing. And I think it could be as a result of the current administration, because we are seeing a much more immigrant-friendly approach to immigration at the moment.
Just to clarify, you said that the E3 approvals are coming through in as little as a month. Are we talking about an I-129 approval?
Correct.
Wow, because they were taking 200 plus days, weren't they, before?
Yeah, so we are seeing ones that have been filed recently get approved before ones that were filed maybe 8 months ago and are still pending.
Wow.
It's quite unusual, actually. There seems to be some kind of backlog still on previously filed ones, and then the ones that are more recently getting filed are coming through much faster. When you file an I-129, change of employer for an E3, you cannot start working until the petition is approved. And that is certain. So I had 2 clients come to me over the last 2 weeks that had their cases had been pending a while. They filed I-129s, change of employer E3s, and they had been told by the attorney that had filed it, and it was different attorneys, that there were portability provisions that allow the person to start working immediately when the petition is filed. So this provision does exist, but it exists only for H-1Bs, and it does not apply for E3s. So if you're in a position where you filed to change employer and you're on an E3, the portability provisions that apply to H1Bs do not apply to E3s, so you cannot start working. So what I've seen, which is really unfortunate, is that these people had filed their E3 change of employer. Their cases were pending a long time because these were ones that were filed even last October, actually. Then in around April or May, they got an R.F.E., which requested for evidence that they were maintaining, they had been maintaining status and their pay stubs. And then I saw in the response to the R.F.E., what had been supplied were pay stubs with the new employer, but they weren't supposed to start working for the new employer. And now their E3 I-129 got denied because USCIS wrote back and said, you've already started working for your new employer, you're not allowed to. The H-1B portability provisions don't apply to E3s. So you've actually engaged in unauthorized employment. So I just want to get the word out there that the portability provisions for H-1B do not apply to E3. If anyone has, told you that you can start working for a new employer as soon as your I-129 petition is filed, that is not the case. And that's really important to know. Yeah, it's like, it's quite unfortunate because the E3 is modeled on the H1B. If you don't have a lot of practice in the E3, there's some confusion as to which provisions that relate to the H1B also relate to the E3. And so you need to be really careful with that, because people are just saying, oh, the E3 is the same as the H1B, so everything that applies to H1B will apply to the E3, but that's absolutely not the case. So just need to be careful of that.
Zjantelle, are we seeing any other areas where people are making mistakes in terms of renewals and applications?
Yeah, I think another thing that I've seen a lot recently is a lot of people that are reaching out and saying, oh yes, well, my visa expired in March, but I have stayed here and kept working because I've still got my I-94 goes till 2022. And then I asked, well, did you have another LCA that was filed from when your visa expired in March? Did you file another LCA? And they're, oh, no, I was told I can just stay here because of my I-94. So it's a very gray area, but one of the things that's critical is that the only way you're authorized to work here in the United States on an E3 is if you have status, which is the I-94 that gives you the E3 status, but then you need to have a valid LCA for the duration of your status here. So if your LCA is expired, you absolutely need to file another LCA that's exactly like the LCA that your E3 was adjudicated upon. So you want to file a replica LCA that carries you through so that you can argue, well, I had a valid LCA and my long I-94. This is still a gray area though. So I don't recommend people doing this for long periods of time. At the end of the day, if you file a new LCA, you're also supposed to file a petition or get a new visa. So we have had clients do this gray area for short periods of time, and it has been okay. But I don't recommend doing it for long periods of time, because otherwise you're going to the consulate with a visa that expired a long time ago and then trying to argue that this gray area is allowed, and it's gray and there's no regulations that say it's absolutely allowed. So you want to just make sure that you're not doing it for too long a period.
Well, Zjantelle, I want to thank you again for your time. These videos can be a little bit long, but they're just jam-packed with really important information, and I want to thank you for providing that. If people want to reach out to you directly, how would they go about doing that?
Yep, they can reach out to info, INFO, at Camissa Markel, and that's CAMMISA, Markel, MARKEL.com. And just a reminder, it's 2 M's, 1 S in the Camissa, because a lot of people will say, in my email, no one responded to my email, and then they check and they put 2 S's and 1 M. So 2 M's, S in the Camissa, info at CamissaMarkel.com. You can also get information through our updates. We've got an Instagram page too that's just Camissa Markel, where we have a lot of your videos, James. And yeah, that's the best way to reach out.
Well, again, Zjantelle, thank you for your time, and we really do appreciate it. Thank you.
You're welcome. It's such my pleasure, James.